We have some big updates for you in the racketeering and sex trafficking case against Sean Diddy Combs. His attorneys are fighting to get a huge amount of evidence suppressed, meaning a jury in his upcoming federal trial would never see it. And in their papers, they reveal a lot more details about the prosecution's case and who the government may have been speaking to. I'm going to break down the filing and what it does and doesn't reveal. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. High-powered defense attorneys for Sean Diddy Combs are fighting back against the federal government, and in a major way. Actually, so major that if they are successful, this whole case, this whole criminal prosecution could be upended. And that is crazy to think about, considering this trial is right around the corner, May 5th, 2025. But to be more specific, what the defense is asking for right now is to make sure a future jury doesn't see a lot of evidence that it says the government gathered through improper search warrants. And we are hearing all kinds of new bits of information, including who was interviewed, whether they were able to corroborate the claims the government is making. This is a big deal. Now, as you know, Sean Combs, behind bars in New York, facing charges of racketeering conspiracy, sex trafficking through force, fraud, or coercion, transportation to engage in prostitution, currently locked up at the Metropolitan Detention Center until his trial in May. And we first learned that Combs was likely under investigation when agents with the Department of Homeland Security raided two of his houses, one in Los Angeles, the other in Miami. This was back in March of 2024. They brought out boxes and boxes of potential evidence. At the time, Combs hadn't been arrested or charged yet, but just a few months before that, in November of 2023, Combs' ex-girlfriend, Cassandra Ventura, filed an explosive lawsuit claiming Combs abused her mentally, physically, sexually during their tumultuous 10-year relationship. Combs ended up settling that lawsuit just one day after it was filed for an unknown sum of money, but the damage was already done. Ventura's allegations, they were out there in the public. A wave of other civil lawsuits followed, and then in September of 2024, Combs was officially arrested at the Park Hyatt Hotel in New York City. His lawyer said he'd come to New York to turn himself in, but the police arrested him a day early. And according to authorities, Combs, reportedly being under investigation for criminal behavior, hadn't stopped him from allegedly having drugs in his hotel room. And as I said, Combs has been locked up. He's been denied bond ever since. Combs offered up a huge bail package worth millions of dollars, but the government argued there was evidence that Combs was trying to influence, maybe intimidate witnesses, even from behind bars, and having him on house arrest, even with private security, it would be a risk. Hey, so I want to quickly thank Upside for sponsoring this episode of Sidebar as we continue our coverage of Combs. Now, Upside is great. It is a free app that gets you cash back on daily essentials like gas, groceries, food. I pump my gas, I can use Upside. Go out to lunch at, let's say, Chipotle, I can use Upside. Maybe pick something up at 7-Eleven, I can use Upside. And why not get cash back when I do all these things, right? And yes, this is actual, real cash back. It's money that appears in your Upside app that you transfer right into your bank account. So once you have the free Upside app, you claim an offer for whatever you're buying on Upside. You pay as usual using a debit or credit card. You follow the steps on the app and you get paid. So to find out how much you could earn, you click the link in the description to download Upside, or you scan the QR code on screen, but make sure to use our promo code SIDEBAR because you get an extra 25 cents back on every gallon on your first tank of gas. But now, let's talk about what's happening now. His defense team has argued that multiple search warrants used to find potential evidence against him and used to indict him were way too broad, and that some of the information investigators found actually goes against their case, that these search warrants were invalid. Okay? And over the weekend, new filings from the defense, they were added to Combs' federal docket. A notice to suppress evidence obtained through search warrants, a memorandum of law to support suppressing certain evidence, and a declaration from one of Combs' attorneys, Tenny Garagos Krishnaswamy, have all been filed. Okay? And that's what we're going to dig into now. What are the arguments here? Because this could have major implications. So what the defense is looking for, according to their notice, is, quote, an order suppressing the evidence and all fruits obtained from the following search warrants. Again, meaning it wouldn't come into evidence. A jury wouldn't see it. The prosecution couldn't use this evidence. A, the January 4th, 2024 warrant to search Mr. Combs' iCloud accounts. B, the March 22nd, 2024 warrant to search his Los Angeles residence and to seize evidence obtained therein. C, the March 22nd, 2024 warrant to search his Miami residence and to seize evidence obtained therein. D, the March 25th, 2024 warrant to search his person and to seize and search two of his cellular phones referred to by the government as Combs number 1 and Combs number 2, and to extract information from those phones. E, The September 16, 2024 warrant to search his person and to seize and search an additional 2 of his cellular phones, referred to by the government as Combs number 3 and Combs number 4, and to extract information from those phones. And F, the September 16, 2024 warrant to search Combs' room at the Park Hyatt Hotel and to seize evidence obtained therein, or in the alternative, granting a Franks hearing. So that is a lot of search warrants, covering a lot of ground, covering a lot of potential evidence, and if the search warrants were improperly served, or they are considered to be too broad or heavy-handed, or they contain false information or misleading information, the argument would be that anything that came from them would be fruit of the poisonous tree, and the prosecution couldn't use it at trial. If that's the case, what would the government have left to support their case other than maybe just witness testimony? That's a question that the defense would love to hear, right? What's left of the government's case? Now, aside from just an automatic suppression of the evidence, one of the other things that the defense is asking for is at least a Franks hearing. Now, that is a specific type of hearing where a defendant can challenge the validity of search warrants. In fact, as cited in this filing, under Franks v. Delaware, if a statement of probable cause contains material false or misleading statements or omissions, then the warrant is invalid and any evidence obtained pursuant to the warrant must be suppressed. So the defense is saying that the prosecution was disingenuous. And while we do get a few clues as to what evidence or testimony the prosecution might have, fair warning here, a lot of the information in the defense's filing is redacted out. It is completely blacked out. We can't see it. It is unavailable to the public, but we're kind of reading between the lines here. So the notice of motion to suppress reads, the government has a duty of candor when it seeks warrants. The nature of the proceeding mandates secrecy, so the process is not adversarial. Precisely for that reason, investigators have an obligation to present a fair picture of the evidence, including both inculpatory and exculpatory facts. Exculpatory evidence is basically evidence that is favorable to the defense. The government in this case utterly failed to do so. It sought several warrants to search Mr. Combs' residences, his electronic devices, and his person, and it presented a grossly distorted picture of the facts. It included only inculpatory facts, and it excluded critical exculpatory evidence that was indisputably in its possession at the time. The government claimed victims were coerced into sex, but it failed to inform the magistrate that, and then there are lines that are redacted, but it goes on to say, the warrants themselves were also grossly overbroad. On a theory that Mr. Combs' entire life was a criminal enterprise, the government sought virtually all limitless authority to seize any evidence related to that enterprise, all his digital devices, and the information they contained. All information in his iCloud accounts, plus troves of records and items in his houses, almost none of which was contraband. By the way, interesting they say almost none of which was contraband. Does that indicate that there was some stuff found that could be considered to be contraband? They go on to say that perhaps the thing that's most troubling is the government received essentially limitless authority to search Mr. Combs' digital devices, which contained a vast trove of personal information. The Supreme Court and Second Circuit have repeatedly warned that it is essentially important that digital device searches must be limited and particularized. The warrants here were not. The warrants were thus unconstitutional general warrants, and the evidence obtained through those warrants must be suppressed. So from there, the defense then provides a timeline of when the warrants were served. It says on January 4th, 2024, so this is before the raids on Combs' homes and obviously months and months before he was ultimately arrested, the government requested a warrant to obtain all the information on Sean Combs' iCloud accounts, according to his attorneys. And then the warrants were served on his 2 homes in March of 2024, followed by an additional search warrant for Combs' person and 2 of his cell phones. I mentioned before there's a lot of redaction in this filing, so we don't know exactly what the government found or what witnesses told them, but the defense is making 2 main arguments. 1, the government's warrant applications contained intentionally or recklessly deceptive statements and omissions, and the warrants were unconstitutionally broad. both arguments, the warrants are invalid. So let's begin with the first argument that the warrant applications had deceptive statements or omissions. The filing states, the duty to include critical exculpatory evidence, again, meaning evidence that's favorable to a defendant, tends to show that they didn't commit the crime, includes a duty to reveal information that undermines the credibility of a confidential informant or other witness. When the government relies on witness statements rather than an investigator's own observations, their credibility is plainly relevant, even critical to the probable cause determination. The government made false statements and omitted critical exculpatory evidence in its warrants applications in this case. This omitted evidence was in the government's possession at the time it sought the warrants. The omissions were intentional, or at the very least, reckless. So, for example, the defense indicates that exculpatory evidence that the government had in its possession was proof that sexual activity here was consensual. But again, they argue that this was hidden in the warrant applications. They go on to say, quote, the core allegation in the warrant applications, and indeed the government's entire case, is that Combs forced victim 1 to participate in FOs. Okay, so victim 1 has never been officially identified, but based on context clues and various filings so far in this case, we believe victim 1 is Combs' ex-girlfriend, Cassandra Ventura. FO, by the way, stands for freak off or freak-offs, which is apparently what Combs called group sex sessions that were sometimes filmed, allegedly involved large amounts of things like baby oil, drugs, according to prosecutors. And in a recent filing, Combs' attorneys seemed to suggest that, yeah, he did hire male escorts to participate in group sex, but that everything was on the up and up, everything was consensual. Although I will say in a superseding indictment, the prosecution amended their claims a little bit, acknowledging that Combs could have committed crimes like sex trafficking in events that were not necessarily considered or fit the definition of freak-offs, but they were more generalized commercial sex acts where something of value was promised or exchanged, or there were commercial sex workers. But going back to the filing, it reads, quote, when it sought the warrants to search Mr. Combs' residences, the government had already obtained one device from victim 1 that contained, and then there's a large section that's blacked out, but that is so important. So if you take everything is true from this filing and based on prior history in this case, a fair argument could be that victim 1 is what started this whole prosecution against Sean Combs. Victim 1 allegedly turning over material and speaking with authorities. It has been reported in prior filings that victim 1 perhaps had sex tapes that she turned over to the government. So that could be what they're talking about here. And the defense claims that victim 1 had a huge financial incentive to make Combs look bad so that she could get a massive settlement. But that information, according to the defense, wasn't included as part of the search warrant application, which they say hides significant context surrounding her claims. The filing continues. By the time it obtained the warrants to search Mr. Combs' residences, the government had also already obtained redacted. Once again, these redacted contradict the government's claims that the FOs were coerced. One of the claims made about these so-called FOs or freak-offs is that Combs used drugs to keep those involved in the sexual performances compliant. There were even claims that following these intense sex sessions, Combs and others would sometimes require an IV drip to help them recover from exhaustion as well as drugs that they'd taken. But Combs' defense team makes the argument that there was, quote, important evidence that wasn't revealed that shows the context of Combs' relationship with victim 1. And, quote, they are the kind of thing that any magistrate judge would wish to know when reviewing a warrant application in a sex trafficking case. Yet the warrant applications contain not even a hint of them. They didn't even inform the magistrate judge that this evidence existed. And then the defense argues that this was, quote, intentionally misleading. So, for example, according to the defense, quote, the government hid evidence that Combs at times discouraged redacted from using so many drugs. So that seems to suggest that Combs had tried to stop someone, maybe victim 1, from using drugs so heavily, but that it was this person's own decision to do so. By the way, even if this motion isn't successful, you are getting a preview of what to expect from Sean Combs' potential defenses at trial, right? We're kind of getting a preview of that. But the filing continues, quote, finally, the warrant applications contain no mention of victim 1's financial motive to exaggerate and falsify. As the government knew, and then you have a huge amount of redactions there, and then it ends, thus provided an unusually strong motive to fabricate years after the underlying events. Then you have another redacted line, and the memo continues. Years after her relationship, she changed her story in a way that would cause maximum potential damage to Combs and thus give him maximum incentive to agree to a large payment. This is exactly the sort of evidence that goes directly to the credibility of the witness whose story provided the core of the government's applications. And the defense claims that the prosecution's alleged lies and other omissions pertain to other government witnesses as well. which, by the way, is huge because we are literally in the dark for the most part about who authorities spoke to as part of this criminal case or who may be called as a witness at trial. So much is redacted or filed under seal, but here the defense claims that the government has refused to provide them with the names of people who are anonymous in the warrants, but we are getting a lot more information because according to the filing, the government relied on information from sex worker 1. But sex worker 1 has also given the government exculpatory information, none of which was included in the warrant applications. And then there's a mention of Assistant 1. So Assistant 1's claims are also called into question by the defense claiming that the government cherry-picked some of this person's statements out of context to use in their warrant applications. And then there is some bombshell news about someone referred to as Producer 1. Now, we believe, we can't confirm it, but we believe there is an argument that Producer 1 is Rodney Lil Rod Jones, a music producer who filed a lawsuit against Sean Combs in early 2024. He claimed that not only was he not paid for the work that he did on the Love album, but that Combs used his influence to intimidate him into doing things like hiring sex workers. And Jones also alleges in his lawsuit that he was present for multiple episodes of abuse and violence that Combs allegedly inflicted on others. He even claims that Combs forced himself on him, groping him, insisting that Jones be present when he was naked or showering. But the motion to suppress states, quote, some of the most salacious allegations recounted in the warrant application came from Producer 1, who the government now says it will not even call to testify at trial. The investigator indicated he had interviewed Producer 1, and Producer 1 had relayed stories about his time working for Combs. Now, the exact details of what Producer 1 told this investigator is redacted, but the defense goes on to say these accusations were never credible. They were uncorroborated, redacted, and the government had boatloads of contrary evidence, including redacted. The government eventually dropped these allegations in later warrants, but their lack of credibility was manifest from the outset. And the defense claims that Producer 1 had financial incentive to lie or embellish, which could be evidenced by Jones' lawsuit if he is indeed Producer 1. And according to the defense, the prosecution revealed it doesn't even plan to have this person take the stand anymore. According to the filing, the government has advised us it will not call Producer 1 as a witness at Combs' trial. Presumably that is because his stories are fantastical and he lacks any credibility, but his lack of credibility was equally apparent in March 2024, meaning when the raids happened on Combs' properties. Now, Jones filed, by the way, his original complaint in February of 2024 and amended it the next month, so that time frame is very interesting considering what's being talked about here. But the defense claims the investigator simply relayed Producer 1's claims without qualification as if he were a credible witness. Now, Combs' attorneys, they also talk about in this filing about victims 2, 3, and 4. Now, I believe this is the first time we have heard about a fourth victim officially, by the way, because in the superseding indictment, there were victims 1, 2, and 3. So I think this is kind of interesting. I mean, all they mention about victim 4 here in this filing is, because so much is redacted, they say the warrant applications included allegations that victim 4 and the government made no effort to corroborate victim 4's claims. And the defense says if the government had then, it would have obtained evidence contradicting her account. So don't know if victim 4 is even a part of this case still, but again, really interesting. And then the defense mentions in this filing Designer 1. Now, most of the information about these accounts is redacted, but the defense alleges that the government took the word of these people at face value and didn't really corroborate them before including their testimony in search warrant applications. And we believe, again, not 100% sure, but we believe Designer 1 could be connected to one of 3 people. Crystal McKinney, a former model who claims that she attended a dinner with a designer and Sean Combs, after which Combs allegedly forced her to perform oral sex on him. April Lampros, a fashion school student who wanted Combs to be her mentor, but instead claims he sexually assaulted her multiple times. Or Brianna Bana Bongolian, a fashion designer who sued Combs last year for allegedly dangling her off a 17-story balcony when she was apparently staying with Cassie Ventura, and she claims Ventura had to step in to stop it. Now, the defense alleges that the government used the innate fear surrounding crimes like sex trafficking to play up their accusations. Sex trafficking, like child pornography, is so repulsive a crime that those entrusted to root it out may, in their zeal, be tempted to bend or even break the rules. When government investigators cheat to obtain warrants, they endanger the freedom of us all. In cases like this, it is essential that courts enforce the requirements of the Fourth Amendment, both to protect the individual defendant's rights and also to deter this sort of government conduct. And the defense claims that if the prosecutors had included the whole truth in their applications, there wouldn't have been probable cause for a search warrant as required by the Fourth Amendment. The defense states, in its zeal to prosecute a famous target, it rushed ahead and violated the law. It submitted an egregiously false and misleading summary of the evidence, thus denying the neutral and disinterested magistrate the opportunity to independently determine whether probable cause existed based on a fair and truthful summary of the evidence. It presented only inculpatory evidence, and it hid all exculpatory evidence. The warrants themselves were also unconstitutionally broad. The charges here reflect an extraordinary legal theory that Mr. Combs is himself an enterprise and that his businesses, his household, his personal relationships, and his sex life were all part of a criminal conspiracy. That broad theory is alleged in the indictment and reflected in the warrants. The government essentially took the position that everything about his life is possible evidence of a crime. And the defense then lists some of the items and information obtained as a result of these warrants, and it covers a lot. So the motion to suppress reads, the government sought warrants in this case that gave it the unfettered ability to search Mr. Combs' residences, his digital devices, and his iCloud accounts. The government's list of items to be seized from his houses was pages long, and it is stunning in its breadth. The government claimed the right to seize, among other things, evidence of Mr. Combs' location or anything reflecting the location of any co-conspirator or witness, which, according to the government, seems to mean anyone who ever worked for Combs or went to a party, utility bills, mail correspondence, address books, all calendars or scheduling information, including travel records, all financial records, including bank statements and credit card statements, plus all cash, property deeds or titles or anything related to property ownership, plus any evidence relating to online financial accounts, any sex toys, sexually suggestive clothing, whatever that means, plus any medical supplies or other materials possibly related to sex, plus any bodily fluid or other material that might contain DNA evidence, any communication or record of communication with any former sexual partner or employee of the Combs business, plus any communication related to the charged offenses, which was, as noted, defined incredibly broadly, with any possible victim, co-conspirators, or witnesses, corporate records, including corporate organizational and ownership documents and employment records, any digital device that might contain evidence, including iPhones, computers, iPads, and cameras. That's very broad. Now, as part of its argument, the defense cites the case of United States v. Way, which addresses the concept of broad warrants. Quote, at bottom, the warrants in Way violated the Fourth Amendment because they authorized the seizure of sweeping categories of materials and lacked any practical tool to guide the searching agents in distinguishing meaningfully between materials of potential evidentiary value and those obviously devoid of it. The same is true here. Indeed, the warrants here are even more infirm. Whereas the warrants in Way authorized unbounded searches of the defendant's business affairs, the warrants here authorized unbounded search of Mr. Combs' business and personal affairs. The warrants here allowed the very sort of general exploratory rummaging in a person's belongings that the Fourth Amendment forbids. Nor can the government evade the Fourth Amendment's limits simply by stating that Mr. Combs was himself a sort of criminal racketeering enterprise, and therefore all evidence of his business and personal life was relevant evidence of a crime. If such a rhetorical trick were allowed, the Fourth Amendment would lose all meaning. And they even reference a case from England way back in the late 1600s that said, Lord Chief Justice Holt once famously challenged a prosecutor, "Hold, what are you doing now? Are you going to arraign his whole life?" And the defense argues that is exactly what the government did here. It charged Mr. Combs' whole life as a racketeering enterprise, and then it obtained warrants to search his whole life. The iCloud warrant, the warrants to search his houses, the cell phone warrants, and the Park Hyatt warrant were individually and collectively exactly the sort of general warrants that the Fourth Amendment sought to prohibit. And at the end of the document, the defense again states their intention to seek suppression of the evidence, or at least a Franks hearing, so that the court can hash out the information that might have been obtained unconstitutionally. Now, as part of the filing, one of Combs' attorneys, Tenny Garagos Krishnaswamy, also included a declaration under penalty of perjury that she herself had looked into these claims on Combs' behalf and swore that the paperwork was true and accurate. And in it, the attorney provides a little more information. For example, it says, following the government's disclosure of the warrants to counsel on October 7, 2024, I learned that on or about December 15, 2023, victim 1, then the rest is redacted, and it would likely be safe to assume that the defense is referring to some sort of interview or meeting between victim 1, again, maybe Ventura, and law enforcement, where she reportedly turned over electronics that contained information about her relationship with Sean Combs. And that date, December 15th, 2023, would be after Cassandra Ventura filed her bombshell lawsuit against Sean Combs. So did she go to them with this new information, or did the government approach her after seeing her allegations? That part remains unclear. But this attorney continues in her declaration to state, I have since learned that those devices included an iPad and a MacBook Air, which both Combs and victim 1 used, and 3 iPhones. The government has been unable to extract the iPad. By the way, little side note, Sean Combs' team in the past, his defense team in the past, has argued that the claim that Combs maintained, let's say, sex tapes or digital evidence to blackmail or intimidate victim 1 to do what he wanted, that it is belied by the fact that victim 1 had this material already. So it's an interesting argument that may come out at trial. Anyway, coming back to the declaration here, Combs' attorney continues, after the government received redacted from the devices possessed by victim 1, the government obtained a search warrant to search Combs' iCloud accounts. This account also contained additional messages between Combs and other alleged victims, as well as witnesses. The government also obtained messages through other means, such as the message attached as Exhibit 28, which came from Assistant 1's device. Thus, by the time it sought additional search warrants in March of 2024, the government already possessed a large amount of relevant evidence, including the FO videos and the messages described above. So the defense wants to know why authorities of the government needed these broad search warrants for Combs' devices and accounts when they apparently already had the evidence they needed. So it's an interesting filing and development in the Sean Combs case. We will see what the response will be from the prosecution and also maybe an order from the judge. Will there be a Franks hearing? Will there be a suppression of evidence? We'll see. But that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.